I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
Alex, that's how we have people.
When you're an assistant public defender, so it's telling me that Mr. Defendant. Yes, sir. Martin, Your Honor. Sean,
Thank you. What are we doing?
You would have to consider on this matter or recovery.
Your Honor, I would like to respond.
Go ahead.
Your Honor, at this time, the people will be requesting the defense bond be modified to the original 100,000 cash surety tax at arraignment. This defendant failed to appear in 2023 an exam and proper witness. He was also out on probation for headstock and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually still has a warrant for a VOP. Other non-support warrants, and the people believe that in this case, the bond would be appropriate at $100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant, the victim picked her up, the argument began while they were arguing. The defendant put the gun to his waist, caught the gun as if to load around, pointed it at the victim, and also at their car that their child was in. The victim was in fear for her life, and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, cut above her ear, and blood on her shirt. We were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic property violence. So we'd be asking the bond set at $100,000.
Response. How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged on conviction. I haven't stayed in Washington County for several years. So when this came in,
He was picked up originally. But I think that this second attempt at bond increase, second bite of the apple, he was released. He's coming to court today. He's ready to.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, the Judge Slate's court.
Those are support cases, is that correct? Yeah.
Or it might be on 14. Arnold said that he had a VOP hearing on 5/2 with Judge Slate.
The initial was a failure to appear when we were before the bank. I did that right before. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns.
It's clear that the defendant understood the charges and the dates. However, his excuse for not showing up was that he was in the hospital. After disappearing for 10 months, I'm left questioning why a bond was set in the first place. When we finally reached him, the bond amount raised further concerns. In my opinion, it's a clear case of abuse of discretion. He missed 2 court appearances.
Back. Just looking for a date on this. I don't know that he. The defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washtenaw County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that
He's not a flight risk? Where was he?
he was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th. He was in the hospital at that time.
Now, Assistant Prosecuting Attorney Morgan Barroso and I have the people looking back at our notes. What we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for a preliminary examination.
Correct.
Just a lawyer informed me that I had a case in Washtenaw County for a different reason. So at that same time, my lawyer told me to go down here, get on video camera. I was doing everything on video camera from the hospital. I saw you one time on the camera. So
It wasn't my preliminary examination.
I was in the hospital, so technical reasons.
Oh, no. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in. You got picked up.
It's like Magistrate Garwood says that all the time.
Under the circumstances, but she couldn't proceed as planned. He was supposed to appear, failed to do so, and then vanished again. It's frustrating because it seems like he may have committed other offenses during this time. What was he even detained for in Wayne County? Then, we hear about new charges, domestic violence and assault, where the victim was in fear for her life. The defendant not only threatened her with a gun, but also pointed it at her child in the car. He struck the victim with the gun 3 times, leaving her with swelling and cuts. This is a serious case, and I don't think we can just let him off the hook easily. His past history of violence adds to our concerns for the safety of the victim and others around him. Now, regarding his custody status, it's clear he wasn't just picking up new charges. He was essentially on the run. After being picked up in Detroit, the defendant was brought here. But let's not forget that while he was out on bond, he continued to skip court and ignored his probation. This isn't a simple mistake. It's a pattern of behavior that shows complete disregard for the law. The idea of giving him another chance at bond is hard to justify. He's shown he doesn't take the legal process seriously. He skipped court, picked up new charges, and now suddenly wants a break? Let's not be naive. He's already demonstrated that he's willing to disappear and evade responsibility. We need to stick with the $100,000 bond. As for his claim that he was in the hospital for 2 months, let's not ignore the facts here. The defendant has made excuses before, and now we're supposed to trust that he's ready to follow through? After skipping out on probation, engaging in dangerous behavior like stalking, and playing hide-and-seek with the law, the idea that he's suddenly going to show up and comply is hard to believe. He needs to be held accountable, and we cannot risk letting—
And he wasn't represented before. He didn't understand he tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and particularly that case, I came back here, I got dismissed off probation. Judge came, but bear with me because I lost my lyrics, I lost my whole neck. So I had to get my body to, you know what I'm saying, take care of this. I lost my whole neck, as you can see.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up, and that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded.
Thank you.
Oh. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Far out? Oh, here. Hang on. Bring it back. Yeah. Step back a second, sir. I'm sorry. Court does call the case of People versus Mohammed Farah. Okay, what are we doing? Discovery's complete. Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, Department does have another matter. Here, which is bond is $2,625. He tells me that he intends and they both that he's granted PR on this case.
Did he post it?
No, he doesn't intend to get ordered and find a granting the bond. That's the matter. He does have safety.
So we get into a chicken or the egg, because I'm not moving it if he's got another bond.
And other cases of CCW, please.
Thank you.
That's correct, Your Honor. Let's be more appropriate to raise that preliminary examination. He posts the bond of the other matters.
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reduction is denied. Bond will continue. Thank you. Park recalls case Peter versus Yusuf Cyrus.
Communicate on during the
The classic, I lost my bearings defense. Right up there with, my dog ate my homework. 10 months of radio silence, conveniently resurfacing only after getting picked up? Sure, sounds like someone eager to clear things up. And that bond? Let's just say the judge isn't buying the Disappearing Act. Enjoy the $50,000 cash bond special. Comes with complimentary regret and a court date.
I'm taking it directly.
Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to that here at the so consideration.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls the case People versus David Davis.
Good afternoon for the people.
Good morning, Your Honor. Judge Overwater, this is public defender on behalf of Mr. Davis. Proceedings. Mr. Davis, would you state your name for the record? Mr. Davis.
What are we doing?
Worked out a plea agreement. Plea form was sent to the court last night.
A plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct. Yes.
7-1.
And John, to where part of the testimony about the truth and all the that's the details got.
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that? All right. You understand also, sir, that that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily.